Good evening, everybody. Keith here. Hoping everybody's had a good day, enjoying life, living life, loving life. Wanted to talk to everybody tonight about the Strawman. And I know it's kind of late, so I probably am not going to get a lot of viewers tonight, but I still wanted to get it out there tonight because it's an important message in regards to a lot of the different problems that we have today, particularly problems with child support, any kind of family court cases, including any kind of actual criminal charges that are being applied in manners that are actually destroying lives. And what I want to talk about is that straw man. Because back in the day, before we had all this birth certificate and everything, there was literally a person or a man or men known as straw men. And they were known as straw men simply because they would put straw in their shoes in order to advertise that they would step up as that surety that we talk about in cases today, so that when a case went before a judge and the man of the house was convicted and sentenced to time, if, say, he was sentenced to a couple years, and that time away from his house would destroy his family, it was completely acceptable for another man to step up into his shoes, per se, therefore straw in the shoes as advertisement for stepping up in place of those shoes. And therefore, in cases where, say, a father got convicted of robbery or something and got sentenced to 10 years, his son could step up in place and do the time so the house didn't get destroyed. His neighbor could step up into place for compensation. So even back in that time, the surety was compensated. So we have to understand the intent of the straw man itself initially, before all of this surplusage came about. And understand that word, surplusage. It's just surplus and then AGE added onto it, surplusage. And because, and if you think about that word, you take something and you give it extra, that's a surplus. And so that's what's happened here in the straw man case, is that surplusage has been added to the government corporate side, and so they are the ones getting the quote compensation. They're correct. They are the ones that the compensation is being conveyed to. And so when we think about this straw man, we have to understand that initially it was all set up simply because somebody else would volunteer to step up or was asked to volunteer to step up for compensatory reasons, so that the father of the house, the man of the house, wouldn't have to do the time and could remain at home and keep the heritage line going. It wouldn't destroy his family. And that was the whole intent, original intent of the straminius homo, the homo, straw man. And today we have that straw man in birth certificate form. And what I want people to understand is the birth certificate, it's known you can't use the birth certificate as identification. And that the birth certificate is a treasury bond. And being a treasury bond, the Treasury, a department of the Treasury, which is an agency of the United States, the corporate United States, hired by the the executive branch of the United States government. That is an obligation of the United States. That's part of the dual citizenship that they talk about in the 14th Amendment. And the second part is the state citizen. You got the United States citizen and the state citizen. The state citizen is dependent upon the 14th Amendment as well as the federal acquisitions regulations in regards to commerce. In order for the states to conduct commerce through that state citizen, they are considered a trustee. But as a state, understand the Sedequate Trust has dual beneficiary and dual trustee positions. And as the state, they are the debtor trustee. As the man, you are the creditor trustee. And as the man, when confronted with the debtor trustee trying to perform acts in executor descent tort, then you have to step up and clarify that as creditor trustee, you are the only one that can fill the capacity of executor of the estate. Because that's what's happening. They're probating the will of the estate. And you are the executor of the estate as well as a co-trustee of the trust of the estate. So understand your capacities in those different things there. As the estate is concerned, you are the executor. As the trust is concerned, it has dual beneficiary and dual trustee. In that trustee position, when the state asserts that they are being injured because they're not able to use that person properly, that's their claim of harm and injury. But that's only due to implementation of the statutes, which they are dependent upon from, again, the federal government. And that's why they are the debtor trustee, because they are the ones that are indebted to the federal government for being able to use that person as executor of the estate. You are the top authority. And the United States is in fact indebted to you for using the estate as the basis of creating a dual citizen so that the states could use that treasury bond, which you can use the treasury bond too. Once you're of age and majority, the TDA account, you give them a call, you tell them, hey, I'm no longer a minor, I'm an adult now, I need to take control of the Treasury Direct account, which is part of the trust, and manage my estate and close that out and transfer all equity capital to my private estate. And that's what we need to start doing. To correct all this stuff about the straw man is to know the real purpose of it. The real purpose is so that we understand we don't have to be surety. We can step up and be surety as long as there's someone else to take care of the home front. So if we do get a second-degree robbery charge and we've got an 18-year-old son that can stay at home and provide for the income of the household, he can do so. So that dad can go off and serve that 10-year prison sentence for robbery. But if he has no son and going to prison to serve that second-degree robbery charge for 10 years would prevent him from continuing his lineage, then he has a right to hire somebody to take his place of surety. And that, again, that was the direct intent of the straw man. And that's why they would go around. And these were, you got to understand, this wouldn't be some guy that made his living off of going to prison. These were people that were of ill report and didn't mind going to prison because at least there they got 3 squares and a cot, which was better than their living as they were on the streets. So even though they were of ill report, it was merely because they didn't really have any trade or business or anything to offer other than that. So think about this stuff and realize the importance of stepping up into that executor position. Sorry about that. Anyway, we have to learn how to step up into this position of being executor and knowing that we can, in fact, if we have that remedy of straw man, if we can hire somebody else to be surety, then that's a clue that as the birth certificate was created and we believe it to be the straw man, then we should be able to use that as the charge off. And that's what we need to start grasping. We need to start grasping that we need to be able to use this as the charge off. And this is the complete and utter foundation of the stories that you hear out there about people being discharged from prison by using that bond and doing the set-off in the correct way. Because technically it is considered the straw man. And used correctly, it's the replacement for the surety. It is the surety. So, again, understand this stuff and remember that everything goes back to intent. And the original intent of the straw man was to prevent any household from being destroyed by an illicit act by the head of the household. He still had some kind of recourse to go back through forgiveness and redemption and all that, to have somebody step into his place so that he could carry on his family. If he had 2 or 3 young ones and he wanted to take care of them, and going off to prison for 10, 20 years was going to be detrimental, and they wouldn't be able to survive, and somebody else would take his woman, that was bad stuff. And it is today. And we need to start realizing that. This is what's happening in all these courts today. Again, like I said, with the any kind of family court action, they're tearing apart the family. And it's the basic foundation of the straw man, and they're using that to do so. So I strongly urge everybody to understand the capacity of the straw man as a surety, because that is in fact what the surety is. Like I said, the states are acting as trustee, but they are only capable of debtor trustee, whereas you're capable of creditor trustee because you're the one that in fact gives credit to the estate to begin with. Because it's your heritage, it's your name. And that estate is created in regards to the U.S., the United States, through a treasury bond. In Title 18 of the United States Code, Section 8, says obligations and other securities of the United States. Bonds. It's the first thing. All bonds. And so that as an obligation of the United States, being the surety, being the straw man, is an obligation of the United States, saying that we have the ability to do a charge off so that we don't have to go to prison. Period. Plain and simple. Yeah, so the more we learn this stuff, the more we to find out the information on what the steps are that lead to that, the better we're off in being able to explain it to others. And the basic, simple thing is that anytime you go into a courtroom, you've got a prosecutor as a third party that is only supposed to present information provided by the plaintiff state. who is initially the trustee, in filing a complaint on behalf of the state, the prosecutor presents a case to the county clerk, who is actor for the state as appointed by the Secretary of State. The chief clerk of each county court is appointed by the Secretary of State. And through that appointment, he is now the trustee. He hands that trusteeship over to the administrator when he hands that case over. Okay, now the administrator is working for the state already, same with the clerk, and same with the prosecutor. Prosecutor's working for the county who upholds state statutes, and therefore they get their check through the state as well. So all three of these parties are working for the state and just passing that debtor trustee position along. And all the meanwhile, people aren't realizing they are the creditor trustee, and all you need to do is assert that. The creditor trustee is the one that gives the authorized signature for the state person. However, the executor of the estate, again, the trustees are trustees of the trust. The executor is the executor of the estate. And all these cases are going through as a probate of will. The will of the decedent, the will of the defendant, the will of the decedent estate. So, again, think about this stuff and realize it's that easy. It's that easy. And there are many codes, statutes, rules, and regulations that all back it up. Everything has to be uniform. The law has to be uniform throughout all jurisdictions. So think about this stuff, and if you have any questions in regards to the straw man and how it ties to the state citizen and yourself, and that authorized signature unambiguously shown throughout your entire life as you were taught in school to use cursive for a signature, and then every bank check you ever signed, every check, whether you issued it yourself or signed it on behalf of as an employment check, you signed as authorized representative. That line that you signed on is not a line. It's writing that says in all capitalized letters, authorized signature. Yes, Karen. When it comes to these cases and they present the facts, what we need to do, and Mark Stevens spoke about this, is pleading guilty to the facts, but not the nature. The facts of the case are resilient. They are there. They are on the record. They exist. They are factual. But what you need to do is fill in the gaps with the facts that they're omitting, which is the fact that they are the debtor trustee and you are the creditor trustee as beneficiary of the trust and executor of the estate. You have the powers to do this. And this is what we talk about with the separation of powers. Article 1, Section 8, Clause 3 of the U.S. Constitution. You've got the 10th Amendment, which talks about the powers not delegated to the United States in the Constitution, nor prohibited by it to the states, are therefore reserved respectively to the states or the people. That's written wrong. We need to correct that because it's the people that delegate the powers within the Constitution to begin with. Okay? And that's the separation of powers that needs to be clarified in the 10th Amendment. And then in the 11th Amendment, that separation of powers needs to be clarified in regards to the Congress, in regards that the executive branch of Congress administrates positive law, and then the corporate judicial or corporate branch of Congress, acting under judicial procedure only and not judicial power, are merely administrating commerce. Period. And so as you walk into the courtroom, you step up into the position of the man as executor of the entire estate, clarifying that as executor, you are the co-trustee known as creditor trustee, who gives credit to the trust to begin with. The state is debtor trustee, who is allowed to use it by your permission and the permission of the United States Corporation through congressional procedures. Lawful procedures. And that lawful procedure is done through an authorized signature. You're the only one that can give an authorized signature. No state representative can come up and sign your name on a document, nor can they come up and sign their name on a document as trustee, whether they're claiming creditor trustee or benefit or debtor trustee. They cannot sign their name, nor can they sign your name. Only you can sign your name in the proper capacity as executor of the estate. And it's all backed up, all in their own records. You don't need to go up and authenticate the birth certificate or anything. All you need to do is clarify the record by, again, like I said, filling in the gaps. So you have continuity all the way through, and then you have closure. I've spoken of that one before as well. So again, like I said, this is a lot later than I usually do videos, but I'm glad everybody stepped in and watched it, checked it out. I think everybody needs to understand you're the one that has the power. I'm going to do a video here pretty soon, a little off the normal subject of law. Hopefully I'm going to be able to blow some people's minds away. I study a lot more than law. And I think people need to start looking inside themselves, getting over that fear, look into that darkness and see that light so you can start shining your own light. I'm hoping that's what I'm doing, is shining my light. And the only way you can do that is by comprehending. Wisdom is power, and power is wisdom. Got to have knowledge to back it all up. So anyway, if it weren't for you guys, I wouldn't be doing this. I hope you'll all pass this on and understand it yourself. It's one of the simplest concepts there is. Know who your power is. It's yourself. It's not anybody else. When it comes to these people trying to ruin your families, it's time to stand up and let them know you have rights and you have responsibilities to take care of. And in that responsibility, you have the right to place surety in its proper place. In its proper place. In the true and correct capacity as as executor of the estate. You have inherent right to protect it at all cost. And that means you have the right to hire somebody else to be surety if you have to. That alone. That alone. It speaks of a lot of different things. It speaks of your inherent ultimate power of contract, powers of sovereignty, your independent belief, freedom of association. So think about this stuff, and again, like I said, if it weren't for you guys, I wouldn't be doing this. God bless y'all. I love you. Have a great night. Peace. Love you guys. Bye.